Well, good morning, everyone. I am John Mann, Director of Education for Lakeside, and our speaker this morning for our Chautauqua Lecture Series, which highlights the region of the U.S. known as the Southwest, is Eugenio Malo Jr. Eugenio is a law professor at the University of Toledo, where he serves as the director of the recently established Immigration Justice Clinic in the UT College of Law. At the clinic, law students under his supervision work with community members who are immigrants to navigate the legal process and challenges that they face. And today we'll have the opportunity to receive the most up-to-date information about immigration law and policy. Eugenio will discuss trending issues and recent executive branch action and share policy along our southwest border. And this presentation will be valuable for those wishing to be well informed on current issues in immigration law and policy. I would ask if you would please mute your cell phones, if you haven't already, and help in welcoming Eugenio Malo Jr.
Thank you, John. Good morning, everyone. It's good to be back at Lakeside. Thank you, John, for the invitation. I am really looking forward to spending the next hour and a half with you. I'm going to try to do 4 things in the next hour because I want to leave 30 minutes or so. My favorite part of the presentation is hearing your thoughts, hearing your questions, seeing what's on your mind. Okay? So we're going to do 4 things. Here's the roadmap. I want to stay true to the Southwest theme. I'm going to place that Southwest theme in a broader historical context. I'm not a legal historian, but we're going to talk about immigration legal history going all the way back 250 years, okay? And then focus on current trends. I'm going to give an immigration law overview for people who might not, right? It's meant to provide some framework to talk about the 3rd bullet point, a focus on 4, only 4. If people have questions, they can ask afterwards. But I'm going to try to focus only on 4 of President Trump's immigration-related executive orders. Maybe you'll see, based on those 4, a lot of themes and day-to-day things that you read in the newspaper or watch on the news stem from those 4. And then I want to end talking about the One Big Beautiful Bill, sometimes called the One Big Ugly Bill, and a growth that we've seen over the past year of immigration detention, okay? So here's the broader historical context. I broke it up into, 7 or 8 different time periods, going back to the nation's founding. So for the first 100 years, I know people throw around the term open border policy, right? I'm going to stay away from politics. I'll talk about policy. When I do talk about politics, it's meant to just provide some framework around these issues, right? Common campaign talking point, the previous administration had an open border. He had an open door policy. That's not what we're talking about for the first 100 years of the country. I am talking really anyone. I don't care if you were a public safety threat. I don't care if you were a terrorist, however terrorists were defined from 1775 for the first 100 years. If you got yourself to the United States, you can stay in the United States. That is a real open door policy. So sometimes, right, people might say, oh, my great-great-grandfather did it the legal way. My great-great-great-grandfather did it the legal way. If you could trace your ancestry back to before 1875, there wasn't an illegal way that they could have come to the United States. It wasn't based on merit or anything else. If you got yourself to the United States, you could stay in the United States. It was really open door. And then after the Civil War, we placed some restrictions. The first restriction ever on immigration law and policy, we excluded convicts and prostitutes, but there were no grounds for deportation. So in immigration law, even to this day, there's ways that we can exclude people from entering, And then even after a lawful admission, there's ways in which we can deport people. And I know there might be some lawyers or law professors in the room. Generally speaking, after we admit you to the country, your due process protections go up. It's more of an effort to try to remove you after we've already allowed you to come in. So, but in 1875, if we let you in, you got to stay here. There were no deportation grounds. And again, the only people that we excluded were people who were convicts and prostitutes. In 1882, the net got wider. It was only meant to be a temporary exclusion, the Chinese Exclusion Act of 1882, right? There was anti-Chinese prejudice and bias in the United States. It was meant only, let's just exclude them for a few years. It stayed on the books and was excluded until 1943, until World War II, right? So 60 years of Chinese exclusion starting in 1882. That's the first time that we've banned people based on national origin. And then during World War I, 1917, we had the Asiatic Barred Zone Act, increasing bars against people from Asia, not just Chinese. A large triangle of countries went all the way to the Pacific, went all the way to the Middle East. Congress passed this over President Wilson's veto. You might see a trend on the next slide. Congress tends to be more anti-immigrant than the leader of the executive branch. You'll see that, you see that in 1917. Maybe you'll see it on the next slide. And then the 1920s were especially exclusionary. We established a national origins quota of 3%. The target here was no longer people from the Middle East or Asian countries. Now the target were people from Eastern European and Southern European countries. And the exclusion continued for all immigrants outside of this hemisphere, outside of North and South America. 1924 restricted immigration to only 2% of people, but Congress really wanted to exclude a lot of people. They didn't use the most recent census data from 1920. They said 2% of the people from your country from 1890, right? It was another way to limit Southern and European migration to the United States. And that continued through 51 until after World War II. 1952 is where we get the Immigration and Nationality Act. I'll call it the INA. Why do I still call it? It's the main statute that we operate under today, right? So of course we're in 2026. People might say the immigration laws need to be updated, we need to be reformed. Maybe one of the reasons to support that claim is that we've been operating with the same statutory framework since 1952, okay? More than, right, 70 years of operating, right? It's been updated. I'll share some updates, but the framework, the mindset, right? People might say we're a different country. We look different. We have different economic needs. We need to update our laws. We're still operating under a 1952 framework when it comes to immigration law and policy. So it kept a national origins quota system. It changed up the formula, but basically, right, we didn't increase the number of immigrants coming into the United States. In some ways, it was less discriminatory. It repealed the Asiatic barred zone provisions, but now we had racial quotas for Asians. And President Truman vetoed the INA, and it went back to Congress, and it still passed. So President Wilson and President Truman both made public speeches, right? It was a veto saying this law from 1917, the INA of 1952, this is against who we are as a nation. Many of us are descendants of immigrants. or our immigrants ourselves. President Wilson and President Truman said we are going to regret this decision. I veto this. Anti-immigrant sentiment in the Congress was high, right? It passed over President Wilson and here President Truman's veto. 1965, we get a little bit more progressive. We eliminate racial quotas, but we established per country quotas that are later eliminated. And you'll see when we talk about current stuff, we still have, we don't call them quotas, we call them limits on people from certain countries. We'll get into that. Then we're in the Reagan administration, President Reagan's administration. The IRCA, the Immigration Reform and Control Act of 1986 passes. President Reagan signs it. It establishes sanctions against employers for hiring non-citizens not authorized to work, right? So we had people engaged in industries where they weren't authorized to work. Congress says we have to do something about this. There were special provisions for agricultural workers, recognition that many of the people who harvest our crops and the food that we eat come from undocumented populations. President Reagan talked about that, saying, listen, we need these laborers if we're going to feed a country of whatever the population of the country was at the time. So we're going to legalize this population. But he says, right, this is President Reagan speaking, we're going to penalize employers who hire undocumented people so we don't have to deal with this undocumented immigration problem ever again. So yes, we'll legalize about 3 million undocumented people at the time, but we're going to go after employers who hire undocumented people. Now we have the benefit of hindsight 40 years later. President Reagan's vision exactly hasn't worked out as he thought it was, neither did Congress, and now we have about somewhere between 14, 15, maybe 16 million undocumented people in the United States. But the big thing out of the IRCA for undocumented people is that it created a legalization program, sometimes called an amnesty program. If you were in the United States January 1st of 1982, and you can prove it, when Congress passed it in 1986, you were on a pathway to lawful permanent residency and a pathway to citizenship. Right? You had to prove that you were in the United States for only 4 years before. That's how generous this legalization program is by modern terms. 4 years. After 4 years, we forgive you. The thinking was you've been here for 4 years. You've sent your kids to schools. You've worked. You've stayed out of trouble. You're a member of this community. 4 years, I forgive you for being here unlawfully. Welcome formally to the United States. We're going to allow you to continue on this immigration journey. 4 years, that's it. Second bullet point down, President Clinton is president. Congress and President Clinton signs the Illegal Immigration Reform and Immigrant Responsibility Act of 1996. It does some things that right, from an immigrant rights perspective, hurts immigrants. One of the things it establishes is that if you are going to file an asylum claim, you need to file it within 1 year, generally speaking. There's some exceptions, but generally speaking, you need to file that asylum application within 1 year of your entry to the United States, okay? And so, maybe this will come up in the questions and answers, right? Asylum is a very coveted immigration status. It puts you on a pathway to lawful permanent residency, puts you on a pathway to citizenship. There's lower humanitarian protections, withholding of removal, deferral of removal, things like that, which don't guarantee that you get to stay in the United States. And we've seen under the Trump administration where President Trump and the administration are actually removing people who were afforded a lower level of protection. One of them made news last week or the week before. I think we removed 11 people to a country called the Central African Republic. Maybe people saw that in the news. They weren't nationals of the Central African Republic. They were from Iran, Libya, North Korea, other countries in which we don't have diplomatic relations to. And we removed them to this country that said, I won't persecute them, but they're welcome to come to the Central African Republic in exchange for some money that the administration has given them, right? So they weren't eligible, these individuals weren't eligible for asylum. Maybe they missed the 1-year filing deadline, but, right? So it creates this hierarchy of different humanitarian statuses. The big thing that IRA does in 1996 is that it penalizes people who have accrued unlawful presence in the United States and they leave the United States. The second part is really important. So here's what Congress passed. They established 3-year and 10-year bars preventing re-entry after being unlawfully present for more than 180 days and 1 year. So if you've been unlawfully present in the United States, in an illegal immigration status, I don't like using the term, but just for presentation purposes, in an undocumented immigration status, either you entered illegally or you overstayed your visa. If you've accrued more than 180 days after that visa or after that status expired, and you leave the United States, you're going to be barred from entering legally for 3 years. If you overstay your visa by longer than a year and you leave the United States, you're barred for 10 years. So Congress, when they passed this, and the legislative record is very, very clear, in 96, when this passes, all these elected officials go on TV and they say, hey, if you've been here longer than 180 days, or, if you've only been here fewer than 180 days, you should leave now so you don't face this penalty. And then people who've already been here longer than 180 days or 1 year, you're covered under this thing. So you should leave now before these penalties accrue. And now we have the benefit of hindsight 40 years later. People didn't leave. That was the problem with this law, because it only penalizes people after they leave the United States. These penalties of 3 years or 10 years are only triggered once you accrue unlawful presence and you leave the United States. Congress thought, great, people are going to leave before they accrue 180 days. People were like, no, I'm not going to leave. I'm going to stay because now there's a penalty if I leave. That is a big mistake from IRA, okay? It penalizes people after they leave and they've already accrued unlawful presence. So it keeps people stuck in the United States. That's what we've seen. Then, last slide on history. 2001, of course, September 11 occurred. In the aftermath of 9/11, we passed the USA Patriot Act. It tripled the number of Border Patrol agents. It's interesting, 25 years later, right? The hijackers on 9/11, all of those individuals entered legally, but one of the responses from Congress was to triple the number of Border Patrol agents. We passed the Homeland Security Act of 2002. It abolished the primary immigration agency at the time, the Immigration and Naturalization Service, the INS. We created the Department of Homeland Security. HHS absorbed a lot of immigration responsibilities in the aftermath. We passed the Real ID Act in 2005. Most people here, I'm sure, have a fancy star on their driver's license to show lawful status. And then the last one that I'll end on, it's interesting from a historical perspective because most of everything I've talked about up till 2006 was targeting immigrants, non-citizens. But in 2006, Congress passed a law that didn't target citizens. or it didn't target non-citizens, it targeted citizens. Who did it target? It targeted citizens and lawful permanent residents who were convicted of certain sexual offenses against a minor from petitioning for family members. So I add that because, right, most of the time when Congress passes immigration policy, it affects non-citizens. And this is the first time where Congress passes a law, albeit a small section of the population, US citizens or green card holders who have been convicted of certain sexual offenses against a minor, but it's affecting their ability to petition for their spouse or children abroad, okay? People have probably seen this map from your US history days. So I'm gonna just talk a little bit, I wanna stay true to the Southwest theme, a little bit about the area in the Southwest, area ceded by Mexico in 1848 after the Mexican-American War, and that little sliver of South Arizona and New Mexico, the Gadsden Purchase. So just, and I'll tie it into relevant happenings today, okay? So Mexican-American War, it ends in 1848. Mexico cedes 55% of its territory, right? It loses more than it has, 55%, including California, Nevada, Utah, New Mexico, most of Arizona and Colorado, parts of Oklahoma, Kansas, and Wyoming. We paid $15 million for it, $632 million in today's dollars. Under the treaty that Congress ratified, there were about 80 to 100,000 Mexican citizens living on this land in the Southwest at the time. And the treaty says that you have a choice to make. These 80 to 100,000 then Mexican citizens had a choice to make. You can stay in what's now the United States, or you can go further south where Mexico, modern day Mexico. So most people decided to stay, and if they did stay, they were granted citizenship if they stayed in US territory. The group of people, based on my research, that left were the really wealthy and people who had close ties to Mexico City, Spain, and Mexico, right? But most people, 80 to 90% of the individuals out of the Treaty of Guadalupe Hidalgo stayed in what is now the current part of the United States, okay? Similar thing happened with the Gadsden Purchase. Smaller amount of money, smaller piece of land, $10 million. Southern portion of Arizona and New Mexico. It was coveted because of a rail road route, and they adopted the same provisions about citizenship as the Treaty of Guadalupe Hidalgo. All the provisions of the 8th and 9th Articles of the Treaty of Guadalupe Hidalgo shall apply to the territory ceded by the Mexican Republic in the 1st article. So if you stay in this small sliver, small piece of land, about 3,000 people, if you stay, you'll become U.S. citizens. If you don't, if you don't stay, you go further south into modern-day Mexico, and you'll retain your Mexican citizenship. The reason I bring this up is because the connection between these two acquisitions to the United States is that Congress decides who gets to become a U.S. citizen, right? So if you go back to the Constitution, Article 1, Section 8 says Congress shall have plenary power over immigration matters. Congress shall establish a uniform rule of naturalization. That's the language which courts have interpreted to mean broadly immigration matters. And when we talk about President Trump's executive orders, President Trump, of course, isn't a member of Congress, right? He's part of the executive branch. But what we've seen, and I don't point the finger at President Trump for this thing, right? Because Congress has been silent since 1952, generally speaking on immigration matters, of course the executive needs to run the show on immigration matters. Congress has been sitting in the back seat for the past 70 years, but that's not the way the founders envisioned it. They were very clear in Article 1, Congress should have plenary power over immigration matters. But if Congress isn't doing their job, everyone's looking at the president saying, I need to act because Congress isn't doing their job. So on citizenship, right, Congress got to decide what was the citizenship status of these individuals in Colorado, California, Arizona, blah, blah, blah. And so Congress gets to decide, and that is true in the Immigration and Nationality Act of 1952, like I said earlier, right? It was written, if you ever read it, I don't know why you would, but Section 301 talks about who's a citizen of the United States, right? And there's a section in there about people living in Hawaii. There's a section in there about people living in Alaska. Why? Because like I said, INA was passed in 52. Alaska and Hawaii don't join the Union until 59. We needed to include, they were citizens, they just weren't states yet, right? So they didn't fall under this umbrella part of the United States. There were separate provisions for people living in Alaska and Hawaii at the time. And then there's a section in there about people living in the U.S. Virgin Islands, citizens of the United States, people living in Puerto Rico, citizens of the United States, right? Guam, living in the United States, okay? Congress gets to decide. And every few years, there's people living in American Samoa. American Samoans are unique. American Samoans are the only group of people who are nationals of the United States. They're not citizens of the United States. And every few years they sue in court for their citizenship, and consistently the courts say, you are looking at the wrong government agency to grant you citizenship. We're the courts. You need to go to Congress if you want citizenship. Just like Congress granted citizenship to people in Puerto Rico, Guam, the U.S. Virgin Islands, you need to go to them. And American Samoans throw up their hands and they say, that's the problem. We don't have representation in Congress to get Congress to pass us a statute to give us citizenship. But the courts say, listen, I can't grant you citizenship. I don't have the constitutional authority to do this. Anyway, the point is that Congress gets to decide who are U.S. citizens. Okay? This slide is meant to convey a hierarchy of different immigration statuses in the United States. So I direct the Immigrant Justice Clinic at the College of Law at the University of Toledo. It's an experiential course. We carry a caseload. Right now I carry a caseload of about 140 clients. I co-counsel those cases with primarily third-year law students. The point of the experience is to give graduating law students practical experience in representing immigrants in immigration proceedings. So we regularly travel. I know it's the summer. Next month, a student and I are driving to Cleveland for a hearing. Okay? She's taking a day out of she's clerking for a firm up in Detroit. She's meeting us in Toledo. We're driving over to Cleveland for this interview. We represent people before the immigration agencies. Most of the time in Cleveland, sometimes in Detroit, depending on where the client lives. So that's my primary job, right? I co-counsel cases, so I'm a lawyer and a professor. To the law students, I'm their supervisor, I'm their professor, I'm their mentor, I'm their safety net to make sure they don't commit malpractice. Immigration law is a little bit unique in the sense that law students at ABA, American Bar Association accredited schools, can practice immigration law. They're the ones signing the pleadings. I also have to sign, but law students get to sign. It's a cool provision under the immigration regulations. In addition to directing the clinic, I teach the doctrinal immigration law course. I've been doing that for about 10 years. And this is the slide I regularly use to law students to communicate where we're at in the course book, right? So, right, U.S. citizens it's the top of the hierarchy. It's always my goal when I'm representing a client to get them to become U.S. citizens as fast as possible, okay? You can petition for more family members once you become a U.S. citizen. You're entitled to a U.S. passport, which entitles you to a lot of visa-free travel, right? You could never be deported from the United States. You could serve on a jury, right? There's a lot of benefits that comes with U.S. citizens. If people were paying attention in the news yesterday, there was a Supreme Court case that came out 6-3, siding in favor of the administration. And I won't get into the super details, but this gentleman was a green card holder, the next category down, a lawful permanent resident. He leaves the United States. He comes back. The government allows him to enter, but they don't admit him to the United States. They only parole him into the United States. Anyway, before he leaves, he commits fraud. He's not convicted of fraud, but he just commits fraud. And then after he comes to the United States, he pleads guilty, he serves his time, and then the United States is trying to deport him. So he hired some lawyers and said, oh, they violated my rights because the government should have used a higher evidentiary standard. And the Supreme Court said, no, you don't need an evidentiary standard. The point of the story is, if you're going to commit a crime, you should first naturalize your immigration status and then commit the crime. You're still going to face legal consequences through our criminal justice system, but you won't have immigration problems. This guy did it in reverse. He committed a crime and then he tried to naturalize. You first need to naturalize, and then if you commit the crime, which I don't support, you'll have fewer problems. You won't have any immigration problems. So naturalization is the process by which lawful permanent residents, the second category down, can ask the government to become a U.S. citizen. Generally speaking, you need to be a lawful permanent resident for 5 years before you submit that application for naturalization. Those are the easy categories: U.S. citizens, lawful permanent residents. The third category is where it gets really complicated. You have to go to law school to really fully appreciate the complexity here. There's a couple of subcategories under visa holders or work authorization. The first subcategory, refugee and asylee, VAWA, U-Visa, T-Visa, SIJS, I won't go through them, right? These folks are on a pathway to lawful permanent residency, which will eventually lead to citizenship. The second bullet down, B visas, are for tourists. F visa are international students. H-1Bs are professional visa holders. H-2A, here we are in Northwest Ohio, there's a lot of H-2A workers. They're agricultural guest workers. DACA recipients, Deferred Action for Childhood Arrivals, a President Obama initiative. TPS, temporary protected status, we'll talk about TPS in a little bit. Parole status, right? Under the previous administration, President Biden's administration, a lot of people came in on parole status, primarily from Afghanistan and Ukraine. These individuals, this second bullet point down, they are stuck in this category. Or, as you're going to see in upcoming slides, they're moving down this ladder, right? So there's an image to the right, it's a ladder. One of the rungs of the ladder is broken because my job as an immigration lawyer is to help people climb the ladder, more security towards U.S. citizenship, but the law is what the law is, and especially in this second category down, the executive has a lot of control over this, okay? They have a lot of control who to bring in for F visas, right? We saw that within the first 18 months of this current administration, right? The president, the administration tried to cancel a lot of F visa holders, international student visa holders, okay? The H-1B, this is the one where President Trump says, I'm going to impose a $100,000 filing fee, okay? This is DACA, he's trying to cut. TPS, he's trying to cut, okay? So there's a lot of discretion or power that the executive has over these categories. And what we've seen in this current administration is that people are moving down in this hierarchy. Not because they've done anything wrong in particular, but the policies have changed under the current administration. And then the last category, people who are undocumented. Sometimes people call these individuals, they might be underdocumented. Maybe they have a visa pending, and it takes years and years and years for that visa to get adjudicated and approved. So something's pending. They're not totally undocumented, but they're underdocumented. They don't have a lawful immigration status right now. Or a term that I think best describes individuals in this category, they're undocumentable, right? Under our current law, there is no way for you to get an immigration status, right? Sometimes people come to my office and they say, Eugenio, you're the 5th lawyer I talk to, and everyone keeps telling me that they can't help given the facts of my case. Can you help? And I say, I would love to help, but I can't help. There's some problem. You entered without authorization. You overstayed your visa. Yes, but I married a US citizen. But for whatever reason, the law doesn't allow you to adjust status. You're the 5th person to tell me that. Why can't you help me? I would love, right? And I just say, the problem's not with me. The problem is with the law. It doesn't forgive, or it doesn't allow you, given your facts, to give you a permanent immigration status. There's only 4 ways to get a lawful immigration status in the United States, permanent immigration status. It's through a family petition. An employer in certain categories, in very certain categories, can petition for you. You need to prove that there are no U.S. workers who are able and willing to do that job. If you're an employer and you want to hire the smartest foreign national, and there is the dumbest American who's applied for that job under the immigration law, you have to hire that dumbest American. Why? Because that person applied for that, but the person has to be qualified to do the job. If you go to the immigration agency and say, hey, this person from Canada is a billion times smarter than this stupid American, the immigration agency is going to say, yeah, but can this stupid American do the job? And if you say, yes, but, the immigration officer is going to say, I have my answer. It doesn't matter that this foreign national is going to bring in more money for you, that this person's going to show up at 7 o'clock in the morning, stay until 7 o'clock at night, not complain about this thing. Yeah, and then the employer's going to say, this American's going to show up 30 minutes late, and he's going to complain every second that he's there. You got to hire the American. That's the immigration law, okay? That's the employment route. Humanitarian, people fleeing their home countries, asylum, right? People who've been persecuted or fear persecution on the basis of their race, religion, nationality, political opinion. And the last one is the diversity visa lottery. We allow people, 55,000 people every fiscal year, countries from underrepresented places, to come to the United States to diversify our immigrant flow. President Trump has threatened to cancel it. He can't cancel it. Congress can certainly cancel it anytime they want, but he can't do it on his own executive order. The last time we had any sort of mass legalization program, we talked about already. President Reagan signed it in 1986. We do have a forgiveness provision. It's called registry in our immigration law. And remember when I talked about President Reagan's IRCA, and it allowed people to legalize their status who's been here for 4 years. We have a provision in the Immigration and Nationality Act today, but you needed to have been here starting January 1st of 1972. If you can prove you've been here in an unlawful immigration status since January 1, 1972, you're eligible for a green card. But of course, I've been practicing for almost 20 years. Only one person has ever successfully qualified for this provision, okay? The point that I want to make here is that every session of Congress, there is a bill that gets introduced. This is the real bill. It's House Resolution 4696. And the reason I show it is because sometimes, you know, depending on the media source that you're watching, they will say, immigration law is so complicated, right? This is a 100-page bill. There's the left, there's the right, there's all of this. It's so complicated. This is the actual bill. It is one sheet of paper. The applicable section says, right, if you entered the United States at least 7 years before the application date, you're eligible for a green card, right? So this would legalize millions of people in the United States. It's very simple. It's very simple language. It would update the INA, grant forgiveness for people who's been here for 7 years. The last thing I'll say about registry is that this is a consistent trend in our immigration laws, but something happened to us after 1972. Every 7 years, 10 years, 12 years, 17 years before this modern era used to be the max. Congress would get together, again, 7, 10, 12, 17, that's the historical trend, where we would say, we forgive you for being here in an undocumented immigration status. We're gonna pass a law, the president's gonna sign it, and grant you a green card. We've gone now 50 plus years without that sort of recognition that many of us come from immigrant families, okay? So that's it, right? This notion that, oh, you know, just show up at the post office, you can mail in a form, you're gonna get your green card. Undocumented people like being undocumented. There's nothing further from the truth. There's very limited ways in which you can get status. These are the 4 ways, okay? Even if you wanna do it the legal way, there's a cap as to how many family-based visas that lead to green cards are permitted under law, okay? There's a first preference category, second, third, and fourth. The numbers that you see on the screen are statutory caps. These are numbers set by Congress, okay? If you add up the numbers, 23-4, the second category, 114, you come up with a number 226,000. That's it. That is the maximum number of visas that lead to green cards for family preference relationships, ever, right? President Trump can't change it. President Biden couldn't change it. Congress has to change it, okay? So there's a limit of 226,000, and that creates a severe backlog in our immigration system. These are people who want to do it the right way. They're willing to be patient. The dates that you see on the screen are dates in which the government is currently processing applications, okay? So the dates I'm gonna use a dramatic example. It's a truthful example, but it's the most dramatic example, okay? So I'll give you that as a warning, okay? So if, let's say you're a US citizen and you have a sister and she's Mexican, okay? You needed to have filed that application for your Mexican sister April 30th of 2001. If you did that 25 years ago, your sister would be on her way to the United States, okay? So 25 years is a long time. But what if you're a bonehead and you didn't do it 25 years ago because you went to some lawyer's office 25 years ago and you were like, gosh, you're telling me it's going to be a 25-year wait? I'll just wait. And now that person comes to you and says, what if I file that application today? I'm sorry to tell you that your sister is going to wait more than 25 years. Why? Because this chart only tells you the date that the application needed to have been submitted to become current. It doesn't tell you how long or how many people have submitted an application since April 30th of 2001, right? It's like if you go to a fancy restaurant tonight and you don't make a reservation and you show up at 6 o'clock, okay? And you go to the host and you say, I'm a bonehead. I forgot it's me and my spouse's anniversary. I didn't make a reservation. Can you get me in? And the host says to you, ooh, I don't know how long it's going to take. Here's what I can tell you. There was another couple that showed up at 5 o'clock, an hour earlier, and I just sat them. That person that showed up at 5 o'clock, also without a reservation, had to wait 1 hour. Now, does that mean you and your spouse, when you show up at 6 o'clock, does that guarantee that you're going to be seated at 7 o'clock? Absolutely not, right? You don't know how many people showed up in between 5 and 6 o'clock. You don't know the availability, right? You don't know the availability. You don't know how many people are ahead of you in line. So you don't know when you're going to get seated. The same logic applies here. So if you apply for a petition today, you don't know how long you're going to wait. Except some smart people have submitted FOIA requests, Freedom of Information Act requests, to get this information. And they wrote a nice piece in the New York Times last year, and they have said that it would take, in this category, you're a US citizen petitioning for your Mexican sibling, 224 years for you to be reunited with your sister in the United States. There's only 65,000 visas available, and I didn't tell you this, I'm going to tell it to you now. There's separate categories for people from China, India, Mexico, and the Philippines. According to Congress, we don't want individuals from certain countries overrepresented in our yearly immigrant flow. And people from the Philippines, Mexico, China, and India want to send more than their allotment. The magic number is 7%. So in this fourth preference category, 65,000, 7%, right? So El Salvador, which is a relatively small country, gets the same number of allotments as Mexico, gets the same number of allotments as the Philippines, right? So Congress says we have a diversity interest. We don't want too many Mexicans, people from the Philippines, India, China here. So this creates a disadvantage. This creates an even longer backlog for these individuals, okay? So we don't have quotas, but we have limits. We have national origin limits, okay? Here's President Trump's 2025. I kept it to just last year, okay? So on his first day in office, President Trump did not waste any time. I will give him that. He signed 3 executive orders, the first 3. One of them, protecting the American people against invasion. His words, not mine. What does he do? That memo talks about no prosecutorial discretion, and it revisits TPS designations, which we're going to get to. He signs securing our border. He adjusts parole policies. He signs protecting the meaning and value of American citizenship, ordering the Department of Justice to reinterpret birthright citizenship, and then late in 2025, holding and reviewing all pending asylum applications and all USCIS benefit applications filed by aliens from high-risk countries. That number used to be a small number, now it's up to 39. So even when people have a legal pathway, the president has ordered the immigration agency to hold and review, and we're not granting benefits even when people are eligible for them, okay? Those are the 4 that we're going to talk about. The first one, protecting the American people against invasion, no prosecutorial discretion, okay? Show of hands. I want people to be honest. No one's looking. How many people here have been stopped by the police, maybe for speeding, and not issued a traffic citation. Brave souls. Good. Congratulations. All of you are beneficiaries of prosecutorial discretion. Fancy legal term, okay? If people here have ever been arrested, hopefully not, but things happen. If you've been arrested, that doesn't guarantee that you're going to get a conviction. It doesn't even guarantee that you're going to go to trial, right? The police might arrest you. They might write up a report. They might give it to the prosecutor's office. The prosecutor will say, this person's 50 years old. This person's a professional person. This person's never had any incidents with the law. This person maybe had a bad lapse of judgment. I'm not going to prosecute this case. I can prosecute this case, just like that police officer could have written you a ticket for speeding, but out of their grace or circumstances, or they ran your license plate and they say, you know, it's not causing any problems. You were only going 11 miles over. It'd be different if you were going 45 miles over the speed limit, right? The police officer exercised their discretion, their grace. They didn't prosecute you. Under the Biden administration, under the Obama administration, we used that discretion favorably in certain cases towards immigrants. President Obama and President Biden's philosophy was, listen, if you're here in an undocumented immigration status and you have 2 or 3 U.S. citizen kids and you work and you pay your taxes and you're not causing any problems to anybody, yes, you're here in an undocumented immigration status, but I'm not going to enforce the immigration laws against you. I'd rather allocate resources towards public safety threats and national security threats. President Trump, on his first day in office, said, I'm getting rid of that discretion. I don't care if you are a mass murderer. I don't care if you overstayed your visa by 2 days. You're equal in my book. I am ordering the immigration agencies not to exercise prosecutorial discretion. So it's not surprising to me as an immigration lawyer when I see these headlines say, ICE is holding a record 59,000 people. Most of them have no criminal record. When this broke last summer, I was like, yeah, that's what he said his first day into office. He doesn't care if you have a long rap sheet or no rap sheet. If you're here undocumented, we're going to try to remove you. There's no exceptions to it. He made it very clear, okay? So, right? Oh, ICE, but this person has no criminal background. He told us very clear in the memo, no prosecutorial discretion, right? You have sometimes people in the administration going on Sunday morning news programs saying that we're going after the worst of the worst, but when they're really pushed and saying, so are you saying if you stop someone, they're dropping off their kid to school and they're here undocumented and Border Patrol and ICE stops them, you're not going to deport them? Oh, no, well, that'll be a case-by-case basis. I know what the case is. That person's going to be detained, and they're going to try to deport them. President Trump made that very clear his first day into office. Okay? Second thing that came under that executive order is to revisit temporary protected status designations. So the big news late last year, the Supreme Court let the administration end TPS for people from Venezuela. 300,000 Venezuelans were affected. Remember, TPS in this hierarchy is right here, okay? They're not on a pathway to citizenship. They can't be, okay? They're stuck in this category, or in this situation, President Trump allowed the designation to end. People sued, and the Supreme Court said, yeah, this is discretionary. If President Trump doesn't want to extend or then it was Secretary Kristi Noem, doesn't want to extend TPS for Venezuelans, he's reached a different conclusion than President Biden. We're the courts, we're not going to get involved. Any day now, we're going to get another Supreme Court case, decision, different population, but it concerns Haitian and Syrian TPS. Okay? Any day now before the term ends in the next couple of weeks, we're going to get a major decision on TPS. Okay? Are they going to side with the Trump administration, allow him to discontinue TPS, or are they going to reach a different conclusion? Historically, when people have brought TPS lawsuits against the administration, they tend to argue that the president couldn't or can't terminate TPS because they would root it in some sort of racial discrimination argument, okay? So under President Trump's first term, he said some things about Haitian TPS that made news for a little bit, right? He called folks from particular countries, I don't curse, so I will spell out the curse word, S-H-I-T-H-O-L-E, which according to lower courts carried some racial animus. So lower courts said, listen, you know, it happened very close together in time. President Trump curses out individuals from certain countries, S-H-I-T, whole countries, and courts have said, listen, that is evidence that President Trump has racial animus against certain people. And lower court said, you can end TPS for lawful reasons, but you can't end TPS for racially discriminatory reasons, okay? But then this goes all the way up to the Supreme Court during his second term. That was the main argument, okay? And the Supreme Court said, well, in the order that he signed ending TPS, he doesn't talk about racial animus. He doesn't talk about race. He talks about country conditions, okay? And the Supreme Court let it slide, which, by the way, is not unusual for the Supreme Court, right? Remember President Trump's first term. People might remember the Muslim ban case, right? President Trump openly tweets, openly says on the campaign trail, I'm going to stop Muslims from entering the United States. He said this, right? This is an AI-generated talk. He says this, and then he comes into office, and he signs an executive order, and the Supreme Court let the Muslim ban stand, saying, well, we're not in the business of really trying to understand what's in President Trump's mind, okay? So he has the authority to do this. We're going to let it slide. Here, the plaintiffs bring a different argument, a slightly different argument. I don't know if it'll hold water or not, is that President Trump and Secretary Noem didn't do what Congress told them to do. Congress has mandated for TPS designations is that the administration needs to do country conditions research. So people from Haiti and Syria, right? President Trump has said, oh, we're going to end TPS for Haitians and Syrians even before the review is done. So the argument isn't based on a constitutional racial discrimination argument. It's based on you're not doing what Congress mandated you to do. So it's a slightly different argument. We'll see where the Supreme Court lands. Second big executive order, primarily focused on last year, right? President Biden brought in about 500,000 people from countries in this hemisphere. Cuba, Haiti, Nicaragua, and Venezuela. He brought them here on parole status. I'm not standing up for President Biden, but if I were standing up for him and defending him, what I would say is President Biden, his thinking was that, listen, nationals from these countries, Cuba, Haiti, Nicaragua, and Venezuela, they're going to come to the United States anyway. Why don't we let them legally come to the United States on parole status and at least learn something about them? So through the parole program, people submitted biometrics information, facial recognition technology, fingerprint scans, and we didn't allow, of course, terrorists and national security threats and public safety threats to come to the United States. But if you had a clean criminal record and you were nationals from one of these 4 countries, Cuba, Haiti, Nicaragua, Venezuela, we allowed you to come to the United States of about 500,000 people. You're stuck in this category. You're never going to get a green card, but you would come for 2 years, and the hope, I think, was after the 2 years, conditions would improve in your home country, and then you'll have to leave. President Trump ended that parole program, even in the middle of this 2-year promise to nationals of these countries. These individuals sued, and the Supreme Court said, President Trump, if you want to end parole, you can end parole, okay? So the Supreme Court handed President Trump a win for revoking parole for 500,000 foreign nationals. Birthright citizenship, okay? So President Trump issued an executive order ordering the Department of Justice to reinterpret birthright citizenship. Arguments were a couple of months ago. This week or next week, it's gonna be a top news story, okay? Birthright citizenship, a lot of the way the media communicates it is that birthright citizenship started with the 14th Amendment, right? All persons born or naturalized in the United States are citizens of the United States and the state in which they reside, okay? It was definitely passed in the 1860s. It was after the US Civil War. It was in response to the Dred Scott case, which is probably one of the worst, if not the worst, decision to ever come out of the US Supreme Court, which held that black people, even free black people at the time, are ineligible for citizenship because of their race, okay? So the 14th Amendment says, and then of course we went to civil war over that issue, over the citizenship and slavery, and 14th Amendment passes, it clearly, right, overrules the Dred Scott case. What sometimes people miss about birthright citizenship is that there were laws even before the 14th Amendment about citizenship, right? The idea of birthright citizenship comes from the common law. And I won't bore you with English common law, but right? The United States was a colony of England, and we adopted their laws before we had our own set of laws. It's called the common law. And the phrase that is giving, that the Supreme Court is going to wrestle with is subject to the jurisdiction thereof. So we don't have 150 years of jurisprudence talking about what subject to the jurisdiction thereof means. We have 500 years of jurisprudence. This comes from the English common law. And very clearly under the English common law, the big categories of people not subject to the jurisdiction of our laws are children of diplomats, right? Diplomats are not subject to our laws. A diplomat can drive drunk, hurt some people, and not face criminal penalties. They're immune. They exercise diplomatic immunity. We can expel them from the United States, but they're not subject to our criminal justice system, right? Same way the United States can be a diplomat in Iran. They hold immunity. This is the way diplomats work. Otherwise, right, people would be subject to arrest all the time for crimes and not crimes. So children of diplomats are not subject to the jurisdiction thereof. They don't become birthright citizens at birth. And enemy occupants of the United States. If Canada or Mexico invade the United States and they bring all their pregnant people over to the United States, all those children in hostile occupation of the United States, they're not going to be granted U.S. citizenship. Those are the limits of subject to the jurisdiction thereof. And it's not comfortable to talk about, Native Americans, when the 14th Amendment passed, were also not subject to the jurisdiction of the United States. So the law changed in the 1920s, but the original subject to the jurisdiction of the United States excluded Native Americans from the 14th Amendment. Now, right, the case is before the U.S. Supreme Court. President Trump signed an executive order saying that if both of your parents are undocumented or only temporarily in the United States, right? So if you, both of your parents are here on student visas and the baby is born in the United States, right? Mom and dad can both be here legally. They're students. Maybe they're studying engineering at the University of Toledo, right? Mom and dad are both here legally on student visas and they have a baby. That baby is not going to be born a U.S. citizen if President Trump's executive order goes through, right? Why? Because President Trump's interpretation of the 14th Amendment, subject to the jurisdiction thereof, he replaces just for conversational purposes, jurisdiction with domicile. He thinks jurisdiction equals domicile. And if there's 2 graduate students at the University of Toledo, they don't have domicile in the United States. Their domicile is in whatever country. They're just temporarily residing in the United States, studying engineering or whatever at the University of Toledo. So oral arguments, I think, didn't go well for the Trump administration, but if I've learned anything in my 20 years of practice, is not to make legal predictions. Last thing on the executive orders is this hold, right? So, there's been some movement on this. District Court out of Rhode Island has said that this memo is unlawful. President Trump has appealed it, but it basically, right, it holds applications. People who came in under the Biden administration, who entered the United States on or after January 20th, 2021, if you're applying for an immigration benefit, it's on hold. So certainly that has an impact on the hundreds of thousands of people who have, who need their applications approved. But, right, this also impacts employers. So you see that in the headlines too. Maximum chaos in immigration leaves employers hanging. DACA recipients are losing protections and work permits because these delays or these holds are taking place, okay? So I have many clients, their work permit status has lapsed, has ended, and they say, hey, can you write a letter to my employer? Sure, I can write a letter to your employer telling them everything that I've done and that the application is pending. And then can you sneak in a sentence saying that I'm authorized to work? I can't do that. I'm right, you're not authorized to work. I'm sorry. I wish you were authorized to work. You have an application for work authorization pending. It's been pending for longer than, right, the government originally estimated, but you're not authorized to work. I can't sign my name to this, right? And then employers call me and they say, well, what am I supposed to do? And I say, I'm not representing you. You should talk to your employer. I'm representing my client. But, even if I were representing that employer, I wouldn't know what to, you can't continue employing this person, okay? One big, beautiful bill. Big thing, lots of spending happened, okay? So this is last summer. There was $100 billion allocated towards ICE. And this is different, right? So this passed, I think it was July 3rd or July 4th last year, $100 billion for ICE. We normally used to spend only $8 billion on ICE enforcement. This allocates $100 billion. And people who really follow immigration news might have seen in the headlines within the past couple of weeks, right? The Senate passed and President Trump signed an additional $70 billion for ICE. That's not, so this is 100 plus 70, when before we only used to spend 8, okay? 46 billion for border wall, 45 billion for increased detention. And where are they getting this money from? They're getting it from my clients. Now we're charging us for asylum applications. It's now $100. It used to be free. Work permits for your initial work permits used to be free, right? The government philosophy at the time was, how do you have any money to get a work permit, right? Once you start working, then we'll charge you a renewal fee. But you don't have any money right now. Now you need to come up with $560. How are you going to come up with $560 when you're not authorized to work? I don't know, but that's what the filing fee is. Parole application fees are $1,000 per person. Now, and then these are adjusted for inflation. So the law passed last year, and there's some inflation that took place over the past year. This has resulted in a growth of immigration detention. The government's not great at updating its statistics, but the last time that they updated it was a couple of months ago in April. 61,000 people are detained This is civil detention. I think there's a lot of problems, don't get me wrong, with our criminal justice system, right? There's a lot of pre-conviction, right? There's a lot of people held in our prisons who haven't been convicted of a crime, right? Maybe they have a bond set and they can't afford the bond, but, right, there's a lot of problems. Here in detention, we're talking about civil detention. Nobody's alleging any crime was committed when we're talking about immigration detention, right? These are people who illegally entered the country. These are people who overstayed their visas, okay? So there's no criminal charges. This is civil detention. And so the numbers have gone up, and there's now more than 200 detention centers across the country. Right? This is a moneymaker for a lot of private corporation and county jails. It was estimated last year that, right, given all of this extra money that One Big Beautiful Bill has allocated, we're going to go up as high as 100,000 people detained on civil immigration charges in the United States. People who live in Northwest Ohio, Stryker, the Northwest CCNO, the Correctional Center of Northwest Ohio, they signed an agreement with ICE last year to house immigrant detainees. And the warden there gave a very open and transparent interview to The Blade, where I pulled this story from. He says, right, the Department of Homeland Security is giving me, I forget the exact number, about $160 per day per detainee. Okay? And he ran the number. He's a business person. He says, it only costs me around $70 or $80 to house this person, to secure this person, to feed this person. So you know what? This is just icing on the cake. It costs me about $70 to operate my jail per person, my correction center. And the Department of Homeland Security has given me $160. That's an extra $90 per person per day that we could do on other things. Okay, so this is a moneymaker for a lot of facilities. County jails benefit from this if they have a contract, and there's a large corporation, Core Civic, right? They're in the business. They have a lot of contracts with these, with ICE on this. So Northwest Ohio has 2 detention centers right now. When I started my practice almost 20 years ago, the main one was the Seneca County Jail in Tiffin, and now we have 2, and they're popping up all over, right? At the start of President Trump's administration, there were only 140 detention centers. Now we're beyond 200, right? Wardens and county sheriffs realize that it's a moneymaker, and it is a moneymaker if that's your viewpoint, right? Now there's $170 billion for detention, okay? So that's it. That's the presentation. I want to hear people's questions and thoughts about anything that I talked about. Thank you.
As I remember, in the fall of 2023, before the presidential election in November, at the end of the Biden administration, there was a bipartisan agreement between the Republicans and Democrats addressing immigration reform. And Trump did not support it, and the vote failed. But what I never heard was what was in the agreement. If it had passed, would it have been a significant improvement in our immigration policies? Was it headed in the right direction, or I just wondered if you'd comment on that.
Yeah, sure. You're right. There was, maybe they call it the Gang of 8, 4 Dems, 4 Republicans. The one Republican that really went on the campaign trail for it, Senator Langford from Oklahoma, right? He's a hardliner on immigration. You're right. It failed. and the comments that you said about Trump not liking it, to be fair, that was candidate Trump, right? He wasn't president at the time, right? President Biden was president. It was focused on border enforcement. There were no legalization programs part of it. It was all, I consider you all friends, just, right? It was all anti-immigration. From an immigration practitioner point of view, right? I'm a member of the American Immigration Lawyers Association. We advocate on behalf of immigrant rights. It's like the immigration bar. AILA came out against it, saying this is all enforcement. This is a bad idea for the country. President Trump also thought it was a bad idea, just for different reasons. I think he's on the record of saying, I want to fix the border problem. I don't want the legislative branch to do it. And, you know, Senator Langford, he's a far-right immigration, right? He crafted this. And he was, this is the strictest immigration policy, and politics got in the way, and it didn't happen. There was nothing, from an immigrant rights perspective, there was nothing good in it. And we couldn't even get that passed, right? Like, if we can't get that passed, how can, right, this is how dirty politics is. Yes.
I'm just curious about there's an awful lot of legalese to all of this, and who's behind it? I mean, Trump, you have to quote Trump as being the advocate for it, but who wrote all of this legalese?
Oh, I mean, right, people might say Stephen Miller, right, is the mindset behind this anti-immigrant phase, but I hope, and I say this sincerely, right, we've been a country for 250 years, and I consider you all friends. We're going through an anti-immigrant phase right now. I think that's clear. But it's not totally unique given our history. I'm not saying that you should go home and have a glass of champagne and celebrate if you think like I think. All I'm saying is that this isn't anything unique given our 250-year history. There's always been periods of anti-immigration. We used to exclude Chinese people just because they were Chinese for 63 years. We still, right? The Supreme Court during the first Trump administration said it's okay, in so many words, to ban Muslims from certain countries. That's current. That's like within the past 10 years. And you know the thing that they cited, the Muslim ban case? They cited the Chinese exclusion ban case in their rhetoric. So in some ways, we haven't changed all that much over these 250 years. There's times of more progressive attitudes towards immigrants. There's times of more conservative attitudes towards immigrants. I'll say this too. We're around 15%, right? So the country, 330, 340 million people. We're about 15% of being foreign-born among us. That's the highest it's ever been. Now, and I say this to students sometimes when they come to me saying, oh my gosh, Eugenio, professor, you know, the world's falling apart, we're not going to have any immigrants, and, you know, what's the point of becoming an immigration lawyer? And I say, what are you talking about? There's more than 50 million foreign-born people in the United States. It's the highest it's ever been. And times in our history where we've approached that 15 million, there's always been a backlash. I'm not justifying it, right? But whenever we approach the 15%, then people start saying we need to put the pause on immigration. I hope we don't go down that path, but if we do go down that path, as a historian, John and I share, right? We both have history degrees, undergrad, before I went to law school. The historical me wouldn't fall off my chair, right? The lawyer part of me might be disappointed. The citizen part of me might be disappointed. But the history part of my brain would be like, we've seen this before.
I'm curious about when you take your law students and you and your clients to your immigration hearings. The issue of those clients being concerned about ICE being there to pick them up after the
Yeah, it's something I talk about with them. There's always a risk.
and what do you
I haven't seen it.
what do you advise them, those who come to you and say, should I go to my hearing? I'm in process. I've been in process for 3, 4, 5 years. What do you tell them?
So before I file the application, I have a real heart-to-heart with them. And this couple that I'm going to Cleveland next month, we had that heart-to-heart. So he's a U.S. citizen. She's originally from Colombia. She overstayed her visa by about 3 years, okay? And she says, Eugenio, should we file this application? And I say, client, if you're driving to work, right? She doesn't have a driver's license, right? She works with fake papers. And I said, if you get stopped by the police, you don't have anything pending right now, right? If you say, oh, I'm married to a U.S. citizen, depending on the Border Patrol or ICE agent that stops you, they're going to say, show me that you have an application pending for adjustment of status for a green card. And they're like, yeah, but if we file, it will bring attention to us. They're going to know where we live. They can come after that. And I say, listen, right, it's your choice. But in my mind, as your lawyer, things might keep getting harder over the next 2 years, right? So you have an opportunity now. I hope your marriage works out, but you're married right now. It's a bona fide marriage. You're eligible for your green card. Let's try this now because I don't know what the future holds. Is there risk? Is there potential that ICE might say, you overstayed your visa for 2 years? We're canceling today's interview. Come with me? For sure. But as you're driving to work every morning at 7 o'clock in the morning, you could also get pulled over by the Woodville Police or any other law enforcement agency, and they can call ICE or Border Patrol, and then you're stuck in detention. It's all about risk, right? But if you're eligible, I'd rather roll the dice right now. But client, I need you on board.
I have a second question that's just the U visa program. Is that still alive
For
at this
sure.
point?
Yeah. So U visas are for victims of crimes. Congress has put a statutory cap of 10,000 visas that lead to green cards. The backlog is at least 6 or 7 years. And President Biden had a policy that you can wait out those 6 or 7 years in the United States. President Trump has the reverse policy. If you eventually get approved, we'll bring you back in 6 or 7 years once it gets approved. But that wait time, you have to wait outside the United States. You can't wait inside the United States. Okay? The thing, and I'll say this, last thing. Right? I had a good conversation with my 15-year-old nieces about immigration policy. I didn't call it discretion. I called it grace, right? President Biden practiced his grace by saying, yeah, it's a 6 or 7 year wait. I'll allow you to stay in the United States. But the thing about grace and discretion, and I'm not justifying President Trump here, but hear me out. It's that discretion, and I know it's implied in the word, is discretionary. You can choose to exercise discretion, you can choose to be graceful, or you can choose not to be. The law doesn't compel you to exercise grace. It's a good thing, I was taught, to practice grace, but the law doesn't compel it. That's why it's grace, right? So President Biden practiced his discretion. President Trump says, I understand I have the choice, and I decide not to exercise that discretion. That's within my discretion.
I'm with you about this not being a phase, so let's get away from the Trump and previous administration issue. Why do you think successive Congresses have failed to tackle the immigration issue and change the law?
Oh boy. You want me to put on my political science hat?
whatever hat you have.
It's, there's no, right? If I'm in a pessimistic mood, it's that there's no political will to do it. It's divisive. It's tough. No one's going to be happy. It's easy to kick the can down the road. But the risk in doing that is that you have, right? We spent 40 minutes, right? The founders would be so disappointed that this was the majority, right? This is where immigration is happening. It's not happening with Congress. It's happening with the executive. And I'm not saying it's President Trump's fault, right? You could say the same thing. President Biden exercised his discretion too favorably. I told you he let in 500,000 people from Cuba, Haiti, Nicaragua, and Venezuela. Is that written into the law? Did Congress authorize that? No way. And to be fair to the Supreme Court, people did sue. People might remember the states of Texas and Oklahoma sued President Biden when he brought in 500,000 people from these CHNV countries and said, hey, this is having an impact on us as Texans and as Oklahomans because now we got to educate these children who we didn't budget for. So President Biden, you are acting outside the parameters of the INA. And you know what the Supreme Court said? They backed Biden, and they said the president has wide discretion over parole authorities. So I hope, right, so that's the, right, the reason I focused on President Trump is because President Trump is president. But if I were here during President Biden's administration, and I did, John will be my witness, I did talk about President Biden's parole authority. And people who didn't like it said we should sue Biden, and the Supreme Court backed the president. And, right, when President Trump canceled the parole, the Supreme Court backed the president. In my mind, and I know, right, I'm a lawyer, so I might view it from a different lens, maybe a biased lens, the Supreme Court just likes backing the president, right? And because there's a long history, given our jurisprudence, that the Supreme Court doesn't get involved in immigration matters. They defer to the political branches of government, right? People sued when the Chinese Exclusion Act passed. And when the Muslim ban passed, right? People sued, and the Supreme Court's always said, if you're part of this affected group of people, there's a political process that you can seek redress. You should call your congressperson, you should talk to your embassy, and they should put a phone call into Washington, but don't force me, the court, to adjudicate these immigration battles. But to answer, I mean, there's lack of political will to solve this problem. And it's going to get solved, whether you like it or not, but it might be by the executive, which, right, is not a functional way to control immigration policy because we've seen drastic swings over the past 4 years.
Hopefully it's interesting. But so I'm from Ohio, but I've lived in Dallas for 6 years. And watching this, we don't see ICE activity. We don't hear about ICE activity. And part of my assumption, to be transparent, is that we're protected as a red state, a severely red state, from as much. So a student can do her own research. I just wonder, like, in those numbers, even though there's a lag, is there ability to research and find out, like, are we being, is ICE as active proportionately in Texas as it is other places?
Oh, I see.
That's what I'm saying.
Yeah. I don't know if DHS publishes statistics like that, but I'm willing to bet money, and I am not a gambler. If there's someone in an unlawful immigration status and they get arrested for a crime in Dallas, the second that person gets fingerprinted on criminal charges, ICE is going to show up at that jail to apprehend that individual. So that's the way a lot of immigration enforcement, it happens with criminal charges and that someone is picked up. Or someone gets stopped, allegedly for speeding, allegedly for following too closely, and then they put a phone call into ICE or Border Patrol. It normally starts with some sort of real or perceived traffic or criminal incident. The people getting picked up at ICE appointments, yes, I get those blurbs too. But it's people, the one I've seen, people who've had like outstanding orders of deportations that were never executed, right? Are there cases that people, right, are there cases that, right, they're at the wrong place at the wrong time? For sure, but majority, I'm not justifying it, but there's an impetus that caused them to get the attention of immigration. Where I feel bad for a lot of folks, right? So I have a lot of Somali clients right now. Minnesota has been hit hard with immigration, right? So if you're a Somali refugee, refugees are permanently resettled in the United States. You're on a pathway to green card. In Minnesota, because President Trump and the administration, right, are emphasizing Minnesota, they're re-interviewing refugees from Somalia in Minnesota. So I have Somali clients right now. They said, are we going to get hit with it? And I say, I don't know, right? Like, I don't make any promises. I don't know what's going to happen. If you do get scheduled for an interview, right, I will do my best for me and my student to accompany you to that interview, but I don't know what's going to happen. The uncertainty is really eating at my clients. So, right, I practiced during the first administration. I lost a lot of cases. I thought, from a practitioner point of view, that it instilled a lot of resiliency in me. And this year, I'm not bragging, right? Few cases are getting denied. Few cases are getting adjudicated in general. And generally speaking, my clients are maybe slightly better than the first administration, but the thing that really causes them pain is the uncertainty, right? An application is pending and it's outside of normal processing windows, right? So clients are thinking, what are they doing with me? I'm eligible for relief. They're just not approving me. I'm going to go back to my home country because I can't live with the uncertainty. At least during the first administration, people were like, I'm denied. They don't want me. I've poured my blood, sweat, and tears in this country. Fine, I'm out. But now it's like, geez, things are so uncertain, and we still have 2.5 years left of this administration. So some people are giving up because it's not that the denial that hurts them, it's the uncertainty. People go to lawyers because they want certainty. But in these times, I can't give them certainty. The best I could say is it's estimated that this case is going to get adjudicated in 1 year. But that's it. It could be fewer than 1 year. It could be longer than 1 year. Yeah, but Professor, how much longer? I don't know. And if there's a lawyer that tells you that they know, they're lying to you. That's the truth. Yeah, but Professor, you've been practicing for 20 years. You have to know the answers. Nobody knows the answers. That's the hard part. Or from a practitioner standpoint, that's one of the joys, right? Navigating through the uncertainty. It's a great learning experience for students. This is a practice, right? You go to a doctor, they're practicing medicine. They don't know if this pill is going to work or not. I don't know if this is going to work or not. That's why it's called a practice of law. I'll give it my best shot. I'll work really, really hard, but I don't have any guarantees for you.
Thank you very much,
Thanks, John.
Eugenio. Thank you, thank you.